who is an attorney and who I know had just had a debate down, I believe, in Anchorage, where he had presented the con position. So we had the pro position discussed, I believe, in March of this year. And so now we're going to have the con position. But again, I just want to remind everyone, thank you very much, Mr. Hutchison, for being here. But again, Mr. Hutchison is here in his private capacity as a citizen and as an attorney, just to give us his legal read on this ballot measure. All right, so Mr. Hutchison, if I may, the floor is yours.
Okay, good morning, everyone. Thank you, Jomo. Very, very kind. Jim, thank you for having me. As Jomo stated, my name is Chad Hutchison. I'm a Senate Majority Counsel. I've been that since 2013, but here I'm speaking on my own behalf as an individual and not on the behalf of the Senate Majority. I want to make sure that's clear. And I'm going to be talking about Ballot Measure 2 and some of the challenges that I see and some of the reasons why at this point in time I can't support it. I've had a debate, that's true, with Scott Kindle down in Commonwealth North via Zoom in this COVID environment. It was headquartered down in Anchorage, but him and I had a good, thorough debate. I like debating Scott. It was a good substantive analysis, I thought, back and forth, and to be honest with you, as I look through this ballot measure 2, there may be some viable points that need good consideration. However, there's also some issues that are included that I think need more substantive analysis, and I'm going to talk about some of the reasons why I think that in a few moments. So, to just summarize the ballot initiative, Jomo has got the summary there, and I'm going to kind of talk about some of the things that I see that people need to be cognizant of. You know, the one that gets the most traction, of course, is ranked choice voting, and that's a good, thorough debate about whether that's a good idea or a bad idea. There's a couple other things in the ballot initiative that I think people should be aware of, and one of it, I look at Section 1. It supports what they call the finding and intent of Alaska as it relates to restrictions on political speech, and it's actually contrary to a prevailing Supreme Court precedent. And it seems to be aimed at Citizens United, which, regardless of what you think about Citizens United, one way or the other, the ballot initiative plants the flag for the state of Alaska in opposition to that holding, even though that is prevailing Supreme Court precedent throughout the land. There is going to be a diminishment of power as it relates to the authority of political parties. I think that we've had a couple hearings now in the legislature where the party representatives, both Republican and Democrat, were not pleased with the way there's going to be new restrictions as it relates to political parties. There's going to be limited political speech in the form of spending for the governor and lieutenant governor. That's something that people should be cognizant of. There's going to be restrictions on certain political contributions, so that's restrictions on political speech. And as we'll talk about in a few moments, that's one of the most important things that James Madison wanted to emphasize when it came to the Bill of Rights. And first and foremost in his mind, when you think about our founding, was they wanted to protect political speech. And in many ways, with this ballot initiative, we're going in the opposite direction. There's a component related to outside funding of certain groups related to some elections. I think it's noteworthy, and I think that Lauren Lehman did a good community perspective. It's circulating in the blogosphere right now, and if you Google it, you'll be able to find it. But he talks about his experience as lieutenant governor and how, if you look at ballot measure 2, they actually exempt themselves from the outside funding disclosures when it comes to ballot initiatives themselves. So in a way, it creates kind of a competitive advantage for ballot initiatives that is not necessarily the same when it comes to other elections, whether it be in the House, whether it be in the Senate, the state Senate, the state House, the governor's office. So that's something that I think needs thorough consideration. If you like ballot initiatives and you like unrestricted ballot initiatives and you think that's good for Alaska, that might be maybe you're more in support of ballot measure 2. If you're not for that, you might take the opposite position. There is a question about candidate designations and party affiliation. The way the ballot initiative is going to work is that the candidates can basically pick their own party affiliations. That's going to run up into some of the Ninth Circuit authority as it relates, and there's a split on that authority about whether that's good or bad when it comes to freedom of assembly and political association. So we'll talk about that more in a moment. So the biggest reason why I think that ballot measure 2 is a challenge is that I have a hard time believing that direct democracy citizen initiatives are the best way to address changes to some of our most important fundamental rights, whether that be voting, whether that be political speech, whether that be political assembly. I mentioned James Madison before. James Madison, of course, was the father of the federal Constitution and the Bill of Rights. If you look at his writings and look at some of the debates that he had, he clearly was not in favor of direct democracy initiative. That's why he creates Articles 1, 2, and 3 in the federal Constitution. He liked separation of powers. He liked the deliberative process. He was a proponent of the legislature, which is Article 1. It's not a coincidence that the legislative body is Article 1 in the federal Constitution. He considered that the people's branch. It was the most important body. He thought that policy and law should go through a deliberative process. That means going through the committee process, having expert testimony, having the equivalent of cross-examination, and having public testimony. And essentially, ideas had to present their best case in order to go through the House and the Senate, and ultimately, again, back to separation of powers, approved by the executive branch. With the direct democracy initiative, you don't have any of that. And one of the things that Madison talked about was he feared the tyranny of a dictatorship, the tyranny of the king, and the tyranny of the mob too. And so that's why he wanted that deliberative process with a representative government where they can go through and do that discipline analysis to see if this is a good idea or not. So I think that's even more apropos as you think about this initiative in particular. We have 25 or 26 pages, depending on what source you're looking at. It's 74 different sections. I went back and did a little research. It's one of the longest initiatives the state's ever had. And it's got a lot of complex issues involved. And, like I said, big changes to a lot of our fundamental rights, which that's a very, very important thing. Voting, political assembly, and political speech. I generally think, if history is an indicator, that initiatives are not the best way to go about these sorts of processes anyway. The one I think about most recently is Stand for Salmon, which was really about anadromous fish and adjacent land management next to waters that had the potential for anadromous fish. And I think that ultimately the struggle with any of these initiatives is that it's essentially settled by bumper stickers and sound bites. And I think that we're seeing a version of that today. Now, the counter is, and this is something that Scott and I talked about a little bit in the past, I've talked about it with others, Scott Kendall, is that we have to have an initiative because the legislature won't take up these sorts of things because they won't take up the issues. There's too much what's termed as vested power, and there's not going to be an interest. However, I'll point out that in 2017, it shows that presumption is untrue. And I'll give you an example. So in 2017, Representative Grenn, which, by the way, he's a common denominator in this ballot initiative too. He's taken to some of these national initiatives that are been placed on the state of Alaska, and draw your own conclusions about whether that's a good thing or not. But Representative Grenn was in the queue at one point in time, an initiative that was going to be an overhaul of legislative ethics. And the legislature actually takes it up, substantially similar legislation, and passes it in 2018 with HB 44. So that's House Bill 44. And, they did it very quickly. And this is the problem with doing things quickly. And this is maybe even a problem with this one, is that it had some unintended consequences that I think that some people talked about and some people tried to raise as an objection, but the legislature was very intent on passing it because they were thinking about considerations about potential repeal on the unconstitutional provisions, and they wanted to do it quicker than if a citizens initiative is passed. If there's a 2-year period where you can't make dramatic changes to some of the provisions. With Representative Grin, we had to go back and redo some of the points that were in the initiative originally, were passed by the legislature, and were deemed to be unworkable in a practical reality. And I'll give you a great example is that, you know, a miner, so Senator Bishop, for example, has got a mining background. The way that policy and procedure was drafted, he couldn't talk with miners about mining legislation. And that's one of the reasons why Senator Bishop was elected, is because he's got a lot of miners in his district. And the way it was written by Representative Grin at the time was that that was a conflict of interest, and therefore he couldn't have any conversations that were not in a public space. And believe me, there were objections about the constitutionality of all of that. And the reason why that decision was ultimately made for the legislature to take it up, because they wanted to adjust it the year after, which is what they ultimately did. So that's quicker than what would have happened if Representative Grin had been able to do it through the initiative process. And that's one thing we have to ponder. If we pass this, some of the changes that we're going to be able to adjust may not happen in a timely manner. So that's just something to ponder as you go through some of this. So going back to the analysis under the federal and the state of Alaska Constitution. As I said before, Section 1 appears to be aimed at Citizens United, which is essentially, in a nutshell, the Supreme Court case says that money is speech, and that it doesn't matter. Corporations, which are essentially groups of associations of people, don't lose their First Amendment protection as it relates to political speech. And this follows kind of a long-standing, multi-decade precedent, not necessarily on First Amendment issues, but the expansion of constitutional rights for associations of people, which is i.e. corporations. And there's been 14th Amendment expansions when it comes to due process. There's been Fourth Amendment search and seizure expansions for associations of people. And so in some ways, some consider the Citizens United decision, another one to think about is Hobby Lobby, a kind of natural continual evolution of the granting of constitutional rights for associations of people, which are corporations. So Section 1 of the initiative, this Ballot Measure 2, appears to be aimed at undoing some of the provisions in Citizens United. And as a reminder, here's what Citizens United actually said. So First Amendment standards must give the benefit of any doubt to protecting rather than stifling speech. That's a quote. And then here's another one. First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. So that's what the Supreme Court of the United States said about free political speech under the federal Constitution. It's important to remember that the Alaska Constitution provides more protection, always interpreted like that. The federal foundation is the baseline, and the state of Alaska's Constitution provides more protection for individual liberty, more protection for what are deemed fundamental rights, which is everything in Article 1 of the state Constitution. That's our version of the Bill of Rights, is Article 1 in our state Constitution. So here's a few things to just ponder as we go forward and look at some of the constitutional provisions that are affected by Ballot Measure 2. So the first one I think about is Article 1, Section 5. That's every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. So in some ways with Ballot Measure 2, when you think about some of the restrictions that they're placing on political speech, we're actually going in the opposite direction, which is contrary to the way the state Constitution is generally interpreted. Next, you go to Article 1, Section 6, and that's the right of the people to peaceably assemble and to petition the government, and that shall never be abridged. Well, here we've already had kind of a evidence from some of the political parties that they don't feel like that is being fully protected under that provision of the state Constitution. Article 1, Section 22 talks about the right to privacy, and this is one that's been broadly interpreted. Certainly, a great example. A lot of pro-life advocates over the years have tried to put what many would consider to be restrictions on spending for abortions, et cetera. And because of that broadly interpreted right to privacy, that they they face challenges, and still to this day they're still struggling with the way to approach that issue. So here we have Article 1, Section 22, the right to privacy shall not be infringed, and the legislature shall implement this section. Now, there's some disclosure rules in sections 15, 16, 17, and 18 that are in ballot measure 2, and some of those may be a good idea, but you have to always balance that with the state's unique, constitutional, strong right to privacy. And I think the argument that's been made in the past is that that should go through a legislative process to determine if that indeed is the right balance. You know, one of the things that you always think about with some of these fundamental rights, it's something called, they have a balancing test, but they ultimately with fundamental rights, it's kind of a strict scrutiny analysis from the court's perspective. But if there's going to be a restriction on a fundamental right, the state has to show that it's necessary to a compelling state interest. And then on top of that, it has to be the least restrictive alternative. And then I think in some cases with some of these provisions with the ballot measure too, finding the balance of what the least restrictive alternative is still an open question. And the legislative process, it's a better seeker and better finder of what that may be, because it's a very deliberative process than with just a yes or no initiative, again, based on bumper stickers and maybe catchphrases. So the other thing I think about as I just ponder the entire initiative process is Article 1, Section 7. I think about due process, and it correlates pretty well with what I think is generally required and generally what the founders wanted as far as when there's big drastic changes of policy. Due process, in my view, is going through the committees, making your best case, having the expert testimony, having the public testify, and then going through the equivalent of cross-examination and allowing, having a thoroughly vetted debate about whether this is good for the state or not. So I do want to talk about the out-of-state spending and the APOC reports. There's been a lot of emphasis on this, and I'm not going to spend a lot of time on it, but I think it's well known that 99% plus of the spending for this is coming from out-of-state interests. You know, they have an organization called Unite America, which is from Denver, Colorado. They have Represent.us, which is from Florence, Massachusetts. And they have Voters' Right to Know, which is from Sausalito, California. And I think a lot of people think about the money being spent and why is it trying to affect the state of Alaska and its elections. As Lieutenant Governor Lehman points out, it's not going to affect some of this federal spending that's happening. It's going to affect the state races, which is interesting. And then it exempts the ballot measures. So I think the concern that some have, if history is an indicator, that they fear that, you know, California has as what some consider to be a problem, which is they have ballot measure upon ballot measure upon ballot measure, and you have to research, study them. You don't necessarily know what's going on. And Alaska has certainly had its fair share of ballot measures that, in the view of some, may not appear wise in the sense that they're not being vetted thoroughly. The fact that they've carved out a little exemption for ballot measures makes some believe that this might be a more routine process in the future, where you basically have millions of dollars coming in from other organizations, and they can use the state of Alaska as an experiment, or state of Alaska as something else, in order to voice the politics of people that don't have to live here onto us that do have to live here. So I think that's a concern. I think that's a viable concern, to be honest with you. As I kind of watch these things over the years, it does appear that in some cases there is you just worry about frequency, and it will become even more common in the future. There's certainly an industry now that I would consider to be kind of a ballot initiative industry and a political science industry that is very lucrative for some. And I think that some people are definitely connected to it in the state of Alaska, and they make money off it. There's attorneys in the state of Alaska that are making a substantial, look at the APOC reports, they're making a lot of money to move these forward. There's a couple of political operatives in the state of Alaska that are making a lot of money to move these things forward. And is it necessarily good for the state? That's an open question. I think that's something that people are going to have to determine. So when Scott and I were at Commonwealth North, we had a little discussion about some of the constitutional cases that talk about, the constitutionality of, they call it instant runoff voting, which is essentially another version of what we're talking about here with this ranked choice voting. And one of the, oh, please go ahead.
I'm sorry, Chad, that was me. I didn't realize our mic was open.
Oh yeah, no problem. Yeah. So I want to talk about a few of the cases that have been used as, and they are correct. I mean, they did they did show that I mean, this has passed a version of constitutional muster in the Ninth Circuit, so that's relevant to the state of Alaska, and with instant runoff voting, as they called it, that was found to be constitutional and allowable. But I think it's also important. So the case is Dunham versus Arnitz. It takes place in San Francisco, and it's in the Ninth Circuit. And it basically allowed for the constitutionality of instant runoff voting. They basically said that okay, that's fine. You can change the way we vote. But I think it's important to know that the Ninth Circuit also said a few other things too that flesh out the picture a little bit better. And one of the things they talked about is that, number one, when San Francisco was considering this, they used the precedent that was already set in a few other cities throughout the United States. Well, at the time, here's what they quoted: Minneapolis, Minnesota, Oakland, California, and Berkeley. And I think you honestly have to ask yourself, are things going well in Minneapolis? Are we getting good policy? At some point in time, I use Minneapolis as an example, but certainly some of those cities have their own struggles. Is instant runoff voting or ranked choice voting, is it working for them? Are we getting the best candidates, or are we getting, and I'll talk about this in a moment, is that with ranked choice voting, the number one candidate doesn't necessarily win. In fact, you can get somebody that didn't receive any of the number one votes, that they can end up ultimately being elected if they, and so in some cases the argument has been made that it's a race toward the middle, but that could also mean a race towards mediocrity, and you might also a race towards people that, are they making bold decisions? Is it bold leadership, or is it something else? And I just think it's interesting. I encourage everybody to look at some of the cities that have adopted ranked choice voting, and then kind of look at what's happening as a society in 2020 and draw your own determinations if things are going well in those cities, and if that's something that we should model ourselves off. It's an open question. But another thing the Ninth Circuit talked about is that ranked choice voting, instant runoff voting, as they say, has a package of potential advantages and disadvantages. And I think that there's actually things that the Ninth Circuit says that undercuts some of the statements that the ballot measure 2 proponents have been saying, which is there still can be manipulation by strategic voting. That's number one. So when we talk about the process now, is it perfect? No. I mean, you can always make improvements to any process, I think. But with ranked choice voting, you can certainly still manipulate it. And the examples that they gave is that, you could decide that your candidate is number one, and you could purposely, maybe along with others, give a 2 to who you consider to be the worst candidate, just so that those 2 can run up to the runoff election, and it could be a blowout. So there can be manipulated voting. So that problem doesn't necessarily go away. And then, as I stated before, I think that there's a real concern that some have that, and this is the Ninth Circuit saying this. This is not Chad Hutchison. It says that under instant runoff voting, a candidate who did not receive the most number of first choice votes can be elected, and whether that feature is a disadvantage or an advantage is, of course, debatable. So I think we have to draw our own conclusions about whether the candidate in the middle, which, I mean, there's an argument to be made, and I get it, for compromise. And in some people, that's what they hunger for, the compromise, and that's certainly, depending on your perspective, that might be a good thing, it might be a bad thing. And it's ultimately, you have to always compromise when it comes to the state budget. There's no doubt about that. And politics is the art of compromise in many ways. It's a team sport. But you also might get a candidate that you would also consider to be mediocre? And does he take bold positions? And you just have to decide whether that's good or bad when it comes to society in general. So another case out of the Ninth Circuit that was brought up, it's called Washington State Republican Party versus Grange. And this has to do with freedom of association and the political parties. And this one was more of a split decision. There was a dissent in it. So essentially, the majority said that, yeah, a candidate can decide what to call themselves. They can say, I'm a Democrat, I'm a Republican, I'm a Libertarian. And that the parties really didn't have a say over what the label is going to be. But there was a dissent. And this goes back to the freedom of association. The dissent was by Scalia and Justice Kennedy at the time. And it says, the electorate's perception of a political party's belief is colored by its perception of those who support the party. And the party's defining act is the selection by conferring upon him the party's endorsement. This is the important part. When the state printed ballot for general election causes a party to be associated with a candidate who may not fully, if at all, represent its views, it undermines both those vital aspects of political association. So what they were essentially saying that the party has an interest, freedom of association goes two ways. Number one is who you can accept to join your association and people that think like you. But number two, it also can give you the freedom to reject people that may not think like you, who may try to get into your whatever association it is and may try to do damage to you. So the dissent in Grange recognized that and said that the parties have an interest, both for their long-term viability, to either accept certain candidates that think like them and also reject candidates that may not think like them, but may try to label themselves one thing or the other. So and the reason why that's important is because that the party's message can be distorted. And this is the quote, is that its goodwill can be hijacked. So if you have a brand, so to speak, then all of a sudden that brand becomes less clear to everybody and there's confusion. Is that necessarily good for the electorate on the whole? I think that the argument can be made that there might be enough confusion as it is anyway. And do we want to necessarily exacerbate that if there isn't some sort of party mechanism to determine what they consider their brand to be? So I think that certainly there's two sides to that argument, and I understand that, and the candidates themselves have on the flip side, of course, this is what the majority found, is that the candidate can say, this is what I believe myself to be. And then ultimately, I think the court said that the voters can draw their own conclusions, which is kind of the point that we're at now. So anyway, that's some of the points that I've pondered over the last couple months. I don't claim to be a full expert on Ballot Measure 2, but I do look at some of the things and just see some of the challenges that I see where I can't support it at this time. And this is some of the things I just talked about kind of lead myself to that position. But that being said, I'd be happy to answer any questions and certainly answer them to the best of my ability, and we can go from there. Thank you.
Okay, thank you very much, sir. All right, well, the floor is open for questions. We do have the chat box open, or you can just go ahead and take yourself off mute. Since no one's jumping in. Oh, I see Clark Milne has taken himself off mute. Yes, Mr. Milne.
Yes, I'll even open up the video at the risk of showing a cluttered background. Thank you, Chad. I think you changed my mind. But one of the interesting, not defaults, is it likely, if this were to fail, that the legislature would pick up any of the good points, the things that, we should try to treat with that. The legislature is going to have lots of things to do in this upcoming session, and you're not a prognosticator. But anyway, hopefully some of the things that are worth doing would be done. Anyway, I thought it'd be interesting to hear your point on that.
Clark, it's a great point, and I can only say it's probably election dependent, and who gets in leadership that would be my first presumption. So I can probably give you a clearer answer after the November election, which may be, to be honest with you, it could be an election month. It could be even longer than that. You know, I think about some of the races, if there's litigation for some of them. So I think that's my best answer for now.
Okay, well, I'll lob a couple of things out.
Sure.
So to a degree, and maybe okay, so first of all, this is not a new concept. If my memory serves, we talked about this concept way back when I was in college in political science. I mean, this has been bandied about for some time as a concept. It seems to me that to a degree, some of this is about trying to fix a problem that folks have been trying to figure out for some time. And that is, frankly, very low voter turnout during primaries, where a very slim minority of citizens, voters, choose who are the candidates that the rest of us vote on come the general election. But I don't know that this really fixes that problem, if that really is one of the things they're trying to address.
Jomo, I think it's a great point, and I take it to heart when you say that a small minority can affect some of these primary outcomes. I agree with that. It would be interesting to study some of the ranked choice voting that's going on in some of these cities that I mentioned to see if there is an increase in voter participation. I'd love to see it, and you know, I'm always supportive of more voters participation. I think it's a good thing for us as a society. I think it's also very important everybody educates themselves, and I think one of the things that the proponents talk about, and I don't disagree with this, is that people will, at least a percentage of them, will try to educate themselves as to all the candidates. And now, you know, life happens, and you know, a lot of people are busy, and you got to take the kids to soccer practice and all these, you know, you got to pay the mortgage and all these things too, fix the sink. So I hope that they're right, that with a ranked choice voting, you're actually going to do more research to understand, you know, for example, you might have 10 candidates one day, who knows? And then you siphon that down to 4, and that goes to the general election, and you do the research to see who gets a 1, 2, 3, 4, et cetera. So I think that some of the intentions of the ballot measure proponents, I actually think in some ways may be good ideas. They really are, except I have a hard time getting there without doing some sort of deep deliberative analysis, which is normally what the legislature would do. And historically, the answer is we've done that in the past, even with ones that people consider to be maybe even disruptive of legislative power. And I think the legislature has taken those sorts of issues up in the past, historically speaking. So that's a few thoughts.
Jim?
Well, Chad, it was an excellent presentation. I personally don't like the initiative process simply because it doesn't root out all the issues that are deliberated in the legislature. As you mentioned, a 25-page initiative is kind of mind-boggling. To try to think that we're going to educate the voter. I always go back to a debate that your boss, John Coghill, and I had many years ago. And it was on the use of the permanent fund for running the state as opposed to the permanent fund dividend. And I was on the we need to use the permanent fund to run the state, and John was on the other side, and his presentation was keep your hands off my dividend, and mine was a long 25 page. So I always fall over on the side that initiative is not the right way to propagate legislation, particularly complicated legislation. And this is significantly complicated.
Yeah. Yeah, similar to Stand for Salmon and a few other ones over the years. Just it's very hard for a lot of the voters to understand the context. Context is very important, like what the foundation is first, and then understanding what changes they're going to layer on top of it. And then you know, the beauty of legislature is you get expert testimony. They can at least give their best hypothesis as to what they think this is going to occur. The departments will testify. And that's a more thorough, disciplined process that I think aligns with the vision of at least the founders of.
Rep. Prox, I see you've taken yourself off of mute. Do you have a question, sir?
I did. I was wondering, way down in the bottom of the initiative, it states that the state, I forget the exact quote, but the state puts some statement on the ballot that says a candidate is not endorsed by a party, when in fact the candidate might want that endorsement. Have you looked at that, Chad, and has that been adjudicated at all?
Well, I can say that in the Ninth Circuit, it has been adjudicated in the sense that the parties didn't want to. So this goes back to the Grange case. So in Washington, where the Republican Party didn't want. They believe that some of the candidates are being a little too liberal with calling themselves Republicans. And the court ultimately rules and says that, hey, look, it's the candidate has that freedom to say this is who I associate with. And ultimately the voters decide whether that's an accurate statement or not. And it's up to the party, and they talk about this, it's up to the party to educate people and say that he presents our values, or he doesn't, and we therefore endorse the other Republican, and of course Democrats too. So the way this initiative is written is that a version of that would occur, which is they don't necessarily need the blessing of obviously if you're doing away with a closed primary in the Republican Party, a Republican closed primary, that the party will not be able to necessarily have the same sort of historical control that it once did. And some people say that's a good thing. Some people say that, it's time. I know the argument's been made that Alaska's a lot of U's and N's and independence, and I get that. And I in some cases, I think people definitely sympathize with that. But that would be a change for the state of Alaska, and the repercussions of which are open to debate. And I think it does raise some constitutional questions where, like I said, it's not unanimous that this was necessarily ruled. There is dissenting opinion at the very highest level. And that's something that people have to ponder when they decide if they're going to vote yes or no.
Mm-hmm. Yeah, it just seems odd that this puts gives the state the power to say whom you identify with. And that just, I don't know. The whole thing is a lot of things to think about. The other thing to think about, though, is that people are upset with the way and I include that in myself now, the way the legislature does business, that things like this get going. And that we've got to sit down and think about that.
And Rep. Prox, you're exactly right. I always think I think that when people being upset with the legislative branch in general, I think about Congress's approval rating. I think about most states, if we looked at their approval rating for the legislatures,
right.
Well, one of the things I remember that at my old firm before I came here is one of the worst things you can do is put a politician on the stand. Juries can't stand them. Yeah, I think about that today. So that's it's always a continual issue.
Again, down to core, and again, I was in college, I'm going to date myself now, got to be 25 years ago, and it wasn't a new concept then. Our two-party system, well, you have to remember too, that at the time we were discussing this in political science, I want to say it was in it was in relation to parliamentary systems where slates of candidates from different parties, where you had many, many different parties that could still achieve seats within the legislating body, where here in the United States, we kind of have a two-party system. It's a binary choice, and it's kind of structured to lead to a binary decision. Whereas in, again, say, England, if enough people vote green for the Green Party, even though they wouldn't necessarily achieve, they haven't achieved the majority that would allow them to have the full slate of seats. If they got 10% of the total vote, 10% of them would be seated. And then, to make a majority, a ruling majority, a legislating majority, somebody would have to deal with them. In any case, again, some of this seems to be a bit of a pushback against that binary choice, particularly as more and more people have chosen not to acknowledge themselves in that binary position.
Yeah, and Jomo, I think you bring up a great point, which is this is always evolving. I think about the founding of the nation. We had the Federalists, and then we had the Democratic Republicans, then the Republicans, then the Whigs. The parties come and go. The Bull Moose Party. In Austria, they have, I think, like 12 different political parties, and they build coalitions. That's who, they have the black, red, green, blue party, and then depending on how the election results are, they have to essentially have these big coalitions in order to have any sort of government. So I think it's in many ways kind of a wonderful experiment. It's always evolving. I don't know if anybody has ever found the right answer that everybody agrees on, and that's all part of the debate. My biggest point today is I think many people are willing to have that debate. We can always do things better, but is this the best way to change it? And through the initiative process, I'm a big believer in deliberation and discipline and study. And I think that aligns itself more with the legislative process and the vision of James Madison, more so than I think the dangers of what I consider to be direct democracy